Hello everyone. Today we're going to dive into the fascinating world of business, political, and legal systems. These systems shape how societies function, and understanding them is crucial for anyone interested in global trade, law, or politics. Let's get started. In this presentation, we'll explore the interrelationship between economic, political, and legal systems in a global context. We'll cover key topics like global law, economic systems, political systems, and the three main legal systems: common law, civil law, and Sharia law. By the end, you'll have a solid understanding of how these systems work and why they matter. Let's start with global law. Did you know there's no single, all-encompassing global law? Instead, each country has its own national legal system, which can sometimes conflict with others. For example, what's legal in one country might be illegal in another. This creates what's called a conflict of laws. To help resolve these conflicts, international organizations like the United Nations create model laws that countries can adopt. These model laws make it easier for nations to interact, especially in areas like trade and human rights. Next, let's look at economic systems. These are the ways societies decide what to produce, how to produce it, and who gets the goods and services. There are three main types of economic systems. Planned economy. Here, the government controls everything: what's produced, how much it costs, and who gets it. Think of countries like North Korea, where private ownership is limited. A market economy. In this system, decisions are driven by supply and demand. Most wealth is owned by individuals, and the government has minimal involvement. The United States is a good example of a market economy. A mixed economy. This is a blend of both systems. Most modern economies like the UK and Canada are mixed. They combine free market principles with some government intervention to ensure fairness. Now let's move on to political systems. These systems determine how a country is governed and how laws are made. There are two main types. Democracy. In democracies, power is divided among different branches of government: the executive, legislature, and judiciary. This separation of powers ensures no single entity has too much control. For example, in the US, the president executive can't make laws. That's the job of Congress, legislature. A dictatorship. In contrast, dictatorships often combine all powers under one person or party. Laws are used as tools for control, and individual freedoms are limited. Now let's talk about legal systems. These are the frameworks countries use to create and enforce laws. There are three main types. A common law. Originating in England, this system relies heavily on judicial precedent. Judges interpret laws and set precedents that future courts must follow. Countries like the UK and USA use common law. A civil law. This system, used in countries like France and Germany, is based on codified statutes. Judges apply the law as written, rather than creating new laws through precedent. A Sharia law. This system is based on Islamic religious principles and is used in countries like Pakistan and Iran. Judges, often called imams, interpret religious texts to make legal decisions. Let's dive deeper into common law systems. These systems originated in England and are now used in countries like the UK and USA. The key feature of common law is judicial precedent, which means judges follow previous court decisions when making rulings. This creates consistency in the law. For example, if a court rules that a certain contract is valid, future courts will likely follow that ruling in similar cases. Judges in common law systems also play a key role in interpreting statutes and shaping the law over time. Now let's look at civil law systems. These systems, used in countries like France and Germany, are based on codified statutes. Unlike common law, judges in civil law systems don't create new laws through precedent. They simply apply the law as written. This makes civil law systems more rigid but also more predictable. For example, the French Civil Code, also known as the Code Napoleon, is a comprehensive set of laws that judges use to make decisions. Next, we have Sharia law systems, which are based on Islamic religious principles. Countries like Pakistan and Iran use Sharia law as the foundation of their legal systems. In Sharia law, judges, often called imams, interpret religious texts like the Quran and the Sunnah to make legal decisions. One key principle of Sharia law is that it's considered divine and cannot be changed, only interpreted. This makes it unique compared to common law and civil law systems. Let's also touch on the difference between criminal law and civil law. Criminal law. This deals with crimes like theft or murder. The state prosecutes the offender, and the burden of proof is beyond a reasonable doubt. Punishments include fines or imprisonment. A civil law. This regulates disputes between individuals or organizations, like contract disagreements. The burden of proof is lower, balance of probabilities, and remedies often involve compensation or injunctions. When people from different legal systems interact, say, in international trade, conflict of laws can arise. For example, a contract valid in one country might not be enforceable in another. This is where international law comes in. It regulates relationships between sovereign states and helps resolve disputes through treaties and conventions. Finally, let's discuss the role of judges in different legal systems. In common law systems, judges play a key role in shaping the law through judicial precedent. They interpret statutes and set precedents that lower courts must follow. In civil law systems, judges simply apply the law as written. They don't create new laws but may perform judicial review to ensure laws align with the Constitution. In Sharia law systems, judges, imams, interpret religious texts and use ijtihad, legal reasoning, to derive rulings. The law itself is considered divine and cannot be changed. Let's talk about judicial review, which is the power of courts to review and potentially invalidate laws that conflict with a country's constitution. In common law systems like the US, judges can strike down laws they deem unconstitutional. In civil law systems, judicial review is more limited, but some countries like Germany have special constitutional courts for this purpose. In Sharia law systems, judicial review ensures laws align with Islamic principles. To summarize, here are the key differences between the three main legal systems. Common law. Precedent-based, flexible, judge-made law. A civil law. Codified, rigid, judge-applies law. A Sharia law. Religious-based, divine law, interpretation by clerics. Let's look at some real-world examples. A common law. The UK and USA handle international trade disputes by relying on judicial precedent and interpreting contracts. A civil law. France and Germany use codified statutes to resolve disputes, ensuring consistency and predictability. A Sharia law. Pakistan and Iran base their legal decisions on Islamic principles, which can sometimes lead to unique outcomes in international trade. To wrap up, understanding business, political, and legal systems is essential for navigating the complexities of global trade and governance. These systems reflect the historical, cultural, and religious contexts of the countries they operate in. Whether it's the flexibility of common law, the rigidity of civil law, or the religious foundation of Sharia law, each system has its unique strengths and challenges.